Oh, sorry, my mic is off. Commissioner Malema.
Thank you very much, CJ, and good afternoon, JP.
Good afternoon, Commissioner Malema.
I just want to understand what do you mean by South Africans are gullible?
What I mean is they tend to believe anything and everything they hear.
But what is
Not
that
all
based
of
on?
them, not all of them. Yes.
Oh, because I just heard a sweeping statement that South Africans are gullible.
No, not all of them, sorry.
Okay. Now, there's a crisis there of 170,000 maintenance applications which are not being resolved. And not so long ago, I think the Department of Justice was launching one of the programs to hand over the defaulters to credit bureaus so that they can be blacklisted. But you can't blacklist people who are not there. They are stuck there by the maintenance courts. And in this case, the latest was 170,000. What can be done to resolve that issue? Because it means there are more than 170,000 children, African children who are starving, who are going through hunger. And the court is not intervening speedily to ensure that it alleviates that hunger and poverty amongst African children. Thanks.
Thank you, Commissioner Malema. That's a very worrying situation. And you are conservative by saying 170,000 children. It could be double. Now, look, the executive, the maintenance courts fall under the executive branch of government. I think if they consult with us, we may find ways of saying, how do you, if it's capacity related in terms of processing these claims, how do you increase capacity over a short period and process these claims as quickly as possible? You're correct that you can't just hand people over to the credit bureau. Some of them may not be aware, right? So that's one aspect that can be done. Increase the capacity of the people who process these claims. But Commissioner Malema, you and me know this is an age-old problem. And probably it's an incident of the patriarchal society issue that Commissioner Pillay mentioned, because mostly it's women that come and ask for maintenance. They are treated in this way. It's something that needs to be addressed frontally, right? As I say, when I tried, I heard on 702 driving to work that there was a big problem in the Randburg maintenance court. So when I phoned the chief magistrate to say, hey, there is this issue, and then the response I received, that was a few years ago, probably 4 or 5 years ago. The response I got from the chief magistrate was, look, maintenance officers don't fall under the courts. They don't fall under the judiciary. I said, but that's strange. They are located in the court. You as the head of the court should have oversight over them. I said, no, I don't, right? I think whether it's the family advocate or who has jurisdiction over them. And I said, no. This must be addressed, right? But I remember talking to the DG to say, look, we need to do something about this, because if it's publicized on radio, we've heard it. Having heard it, what have we done about it, right? It's away from me. But I suppose as DCJ, Commissioner Malema, nothing prevents me from saying to the Chief Justice, this affects a large component of South African society. We need to engage the executive in coming with an effective way of ensuring that there is a credible and effective system of dealing with these things and making sure there are no backlogs that are created. That's all I can say, Commissioner Malema. I acknowledge the problem.
Thank you, Commissioner Malema. A third question now.
What's that, ma'am?
You've asked 2 questions.
Can I just have a follow-up, brief follow-up?
All right, make it brief.
JP, they say in this regard, sexual harassment, that it's unlikely that a leopard will change its spots without remedial attention. What are your thoughts about that?
I'm sure there could be truth in that, but I want to believe that when disciplinary action is taken against an individual for having done something that that individual should not have done, that would say to that particular individual, this is not a go, this is no go area, don't do it again. I think I can leave it at that. Yeah.
Just a quick follow-up. JP, when you speak to people who come to you that were being harassed here by this and that, and you ask the question, how has it been going? For how long has it been going? They tell you, what do you want me to do? And then they say, no, we just wanted to ventilate this matter with someone senior, and you leave it at that. Had you proceeded to confront that person or even subject that person to some form of a disciplinary process against the wishes of those complainants, was that not going to be harassment on its own?
Commissioner Malema, thanks for that question. They had specifically no, they don't want to go there, but they gave him permission to confront the person, and I confronted the person, and I told him to stop. Yes.
Thank you, Chief Justice. JP, I just have two sort of broad lines of inquiry, not necessarily questions, but just to get your philosophy as the potential Deputy Chief Justice. And I was very pleased to hear in your presentation that you highlighted the problem of poverty and inequality that bedevils the creation of the new South Africa. Now, as the Deputy Chief Justice, how do you see the role of the Constitution in addressing the economic inequality in South Africa? There are many theories of what a Constitution does. One of them is that it's preservative. In other words, it preserves the rights that exist at the time of its adoption. The other is that it's transformative. It seeks to rupture the existing relations, particularly around property, which is a defining feature of wealth inequality. But it's a contentious topic about why do we have so much inequality and so much poverty despite an apparently progressive constitution? So that's the first area I would like your views on, about how do you think, as a Deputy Chief Justice, you will theorize the transformation of the economy through the lens of the Constitution?
Thank you very much, Commissioner Ngcukaitobi, for that question. I think in one of my previous speeches, I've confirmed the statement you make that we adopted what is called a progressive constitution that seeks to uplift the plight of people. I've got people who represent legal formations here, because one way in which the Constitution can be used is to target particular bottlenecks that are continuing to confine South African people to inequality and poverty, to identify those particular bottlenecks and then bring carefully crafted litigation for the court to grapple with and ensure that the Constitution is applied to deal with that bottleneck. Commissioner Ngcukaitobi, you know, the issue of Rule 46A has been raised by a number of judges as a problem, in the sense that that is the rule that is used by powerful players like the banks to further take away their property, especially their houses. One aspect of it that has been mentioned is the issue of substituted service. To say, in many instances that judges have come across, the first time a hard-pressed defaulting bond holder knows that his or her house is under threat is when the sheriff knocks at his or her door. There's something wrong. There's a misalignment somewhere. You should be the first to know that someone is taking action against you. And you should take up that opportunity to see how you can negotiate. But as the judiciary, I think we need to find a way of reforming these legal rules that form part of this conservative legal culture that we've built in South Africa, that dismantles that conservative legal culture and understands the plight of people to whom the Constitution applies. So I've identified that, but I go back to my initial answer. It is a very contentious area because the haves are always eager to litigate, and they have deep pockets in terms of litigating. But the people who may want to attack particular areas don't have the money to do that. Let me give you another example, and this relates to land. In the early years when I was still at Legal Aid South Africa, we dealt a lot with people who were given land but didn't know what to do with it. And I say that advisedly because those are the reports that we got in those gatherings. Now, land is a very important facet of a person's human dignity. This is my land. I can build on it, I can live on it. But if you come from a system that has relegated you to a non-entity that has blocked you away from knowing how to use land, how to access finance, right? You will find the example you get on people getting RDP houses and selling them and going back to live in shacks. It's a deep societal problem. So that one doesn't answer your question, but I think the executive needs to be alive to these realities to ensure that in its programs, it factors in the enabling requirement in what they should do in assisting people come to terms and actually take the right action. Now, I mentioned the issue of identifying bottlenecks. We have a number of legal professional bodies, and I've said to them in my speeches to their AGMs, why don't you create a legal fund? And I give the example of Thurgood Marshall, Justice Thurgood Marshall in the US, when he was a lawyer of the NAACP. He realized the NAACP has no money, but there are a lot of social transformative cases that he wants to take that can be funded. And they allowed him to create a fund, a legal fund, which would fund this litigation. And he was successful. So I use that example, and I want to use it in answer to you partly to say we've got organizations in this country that can establish those funds and that can interact with societal formations or with communities. I chair CAUSA, which is a grassroots access to justice level, and the needs for legal services is very big. So through those funds, I think critical areas like those you've mentioned can be funded from deep pockets to make sure that the Constitutional Court is actually challenged to develop the Constitution in the way the Constitution was conceived. Let me stop it there.
Yes, thank you. I mean, suppose primarily what judges do is to interpret the statutes or the common law or the Constitution, but in a given case. But that interpretation can hinder access to property by disadvantaged persons. But then the only way the judges can do that is to be conscious every time they interpret the Constitution what they're trying to do. In other words, are they trying to rupture the existing economic relationships? Or are they trying to preserve them even unconsciously? And that is where I think I always have a difficulty, is that you get a judgment that is worded in apparently neutral terms, but its impact is radical in preventing black people from accessing property. Because at the time the case was argued, just no one thought about the implications, because everyone thought, let's apply the rules. But they have forgotten that those rules developed in a socio-economic context of
Yes.
marginalization. So I just want your view on that issue of that sort of intellectual awareness that the law operates in a social context, but that context is to be sort of broken by this new constitution.
That is a function of conscientizing the judiciary. One of the judges we have appointed in Gauteng is extremely radical. But if you listen,
I don't want to know the name.
but he's radical in a positive way,
Oh, I see.
because he's challenging us who've been there for 20 odd years to say, you've been here and this is how you've been interpreting the law. You've sold out. That's the language he's used.
What do you say to that when they say you sold out?
Well, selling out is too strong to put. But Commissioner Ngcukaitobi, you know, we have educational problems where judges are exposed to training if they're going to sit as equality court judges. I want to think that training can be embedded deeply for judges to actually understand what is it that they are going to be dealing with on the equality law front, not just process. It goes deeper. So social awareness, you know, and equality awareness, the past will come. I mean, that judge that I mentioned said to me when I said, but you didn't put your name forward to be trained on equality court cases. He said, no, a white man won't tell me what apartheid did to me. That's a very profound answer. So I think we need to embed more of these training sessions that actually challenge us and actually enables new incomers to the bench to actually understand. Because generationally, maybe we have sold out in being conservative and in interpreting things in one way, right? So I think my answer is that there needs to be this continuing engagement. And, you know, when I interact with colleagues in the continent, because some of them are more conservative than us, I'm sure you're aware of that, and ask, but you guys, you unshackled yourself from colonialism years before we did, but we've advanced further than you. Why? You know? So it is this conservative legal culture that I mentioned that's shackling us. And once we admit it as the judiciary, then we are well on our way to interpreting the Constitution in the right direction.
And then just lastly, JP, on the issue that you've dealt with, I think you gave the judgment in the competition court, although it was about jurisdiction in the Group 5 case, where you were in the minority. Regrettably, you agreed with me, but you were in the minority, so it didn't really help my client. But there's something important about that, which is you're talking about a conservative legal culture, and competition law is a particular area where this conservative legal culture plays itself out, and where the Constitution is playing a catch-up game, and there is no infusement of constitutional values within the interpretation of that statute called the Competition Act of 1998. And I want to single this out because if you compare it, for instance, with labor law, the judges are quite happy to infuse labor law with constitutional values. or you compare it with land law. They are quite happy to infuse land law with constitutional values. But they are extremely reluctant to infuse competition law with constitutional values. Can you just articulate that for us and explain what your approach will be to that particular statute? And I ask this deliberately because you've got experience in it. You've written a judgment on it. You've had the debates on both sides.
I think, let me repeat, it's the conservative legal culture. And before I answer that one, there's another one that you're not mentioning. It's the Standard Bank case. As the leadership of the bench, we realized that the big players with deep pockets were actually using the current legal processes to actually disable vulnerable people. Because Pretoria has jurisdiction in Soweto, they could issue process against a Soweto bondholder in Pretoria. For that person to go to Pretoria, he or she may need to catch 3 or 4 taxis to get to Pretoria. That's one. 2, we say, but this claim is in the jurisdiction of the magistrates court. Why not issue this thing in the Soweto Magistrates Court, where this litigant is located? And we issued a Rule 16 notice and invited people because we knew what we were trying to solve. But legal culture trumped us because the SCA said, no, you've got inherent jurisdiction. And inherent jurisdiction is an incident of the common law. It says the High Court has inherent jurisdiction. But we understand that. We've got inherent jurisdiction, but we say, despite that jurisdiction, let's understand the realities that we have now, that this inherent jurisdiction is leading to injustices. The SCA told us to get lost, and the Constitutional Court told us to get lost. So in Group 5, it's the same thing. Co-conspirators of Group 5 went and pleaded guilty and got fines on direct competition law issues. And Group 5 decided to say, no, the High Court has jurisdiction, simply because they want to bypass the tribunal, which is the body that is properly capacitated to deal with competition law issues. I went out on a limb on my own because I believe that I was correct. And you can talk to the chairperson or the JP of the CAC now. The effect of the majority of the Group 5 decision is that the tribunal is now routinely bypassed. And I don't think it's an unintended consequence of how we decide these cases. But I think to actually interpret the jurisdiction of the High Court that strongly, to say you can actually give it jurisdiction in such a way that it makes inroads into the competition arrangements that give that jurisdiction to competition law bodies, it's a problem. Thank you very much.
Thank you, Chief Justice.
Follow up, CJ.
Thank you, JP.
And that was 3 questions, Commissioner Ngcukaitobi.